So now let me take this opportunity to welcome you to Breakfast with Brodies. This seminar programme is designed specifically for NQ lawyers. It's presented from a UK top 50 firm and Scotland's leading firm, Brodies. Our free to attend law programme will cover a range of topics every week up until the 7th of August. With support from the Law Society of Scotland, you can find out more about the different seminars that we've got available by visiting the website brodies.com. As we develop the programme, we would like to hear your feedback and suggestions so that we can continue to tailor the programme to give newly qualified lawyers access to quality training. My name's Garry Sturrock and I'm an associate from the family law team at Brodies based in our Aberdeen office. Joining me today is Zoe Ray, my colleague, who's an associate in our Glasgow office. Zoe is going to assist in reviewing any questions that are asked and sent through the Q&A function and will assist me in the end of the presentation in responding to those questions. Today, I'm going to be providing you with an introduction to contentious child relocation, a challenging area for family law solicitors. I intend to cover the methods of dispute resolution, including the process of litigation, important factors for parents that are thinking about relocating, and evidential considerations, views of the child, and approaches of the Scottish and English courts in litigation. So let's begin. Over the past 2 decades, relocation of children from Scotland has become an increasingly prevalent issue, with a host of cases available on Westlaw and the Scot Courts website. The increase in ease of international travel, the removal of border restrictions within the EU, and globalisation has resulted in an increase in the number of individuals of different nationalities starting families. We've also experienced an increase in the number of mobile families and parents being required to live and work abroad. Relocation cases are always difficult for people involved. Those who've seen the film Marriage Story will know that decisions to relocate are difficult ones for the court, and it can be really distressing for the parties involved, especially as they're often made in the aftermath of a difficult breakdown of a relationship. Typically, there's little prospect on occasion of the parties reaching a compromised agreement, as it can involve a binary decision. Either the child goes or the child stays. So why does it happen? The most common reason for proposed relocation is the desire of the child's primary carer, which is usually the child's mother, to return to their home country following separation or to reside with a new partner. Increasingly, and I find working in Aberdeen with its connections to oil, applications arise where one parent wishes to relocate for economic reasons, most commonly an employment opportunity. Often the move is opposed by the other parent, who has a concern about the diminution of the relationship with their child. We'll discuss later about the paramountcy of the best interests of the child, and therefore applications to the court tend to be framed to say how a proposed move will better a child in terms of their welfare, and not focus solely on the desires of the parent. Typically, we see applications framed to justify a move for relocations for reasons such as the proposed move allowing the primary carer to better provide the child financially, that the primary carer would have greater childcare support in the intended country. The move would be better for the child in terms of education provision or healthcare, that the intended country of migration has a better climate, lifestyle, or opportunities for the child, including physical or recreational activities, or for reasons such as the child being able to gain a better understanding of their own culture, their primary carer's culture, and foster relationships with family in that country. And generally, we see parents trying to justify a move on the basis that the quality of life of the child and the primary carer would improve. When making important decisions about relocation, parents have a duty to consult and make decisions bilaterally. Parents ought to give their child an opportunity to express a view if appropriate and try to make decisions where the focus is on the welfare of the child. A court should only intervene if it's better that the matter be regulated than not, commonly referred to as the no order principle. A commonly held misconception is that litigation is the only way to resolve contentious disputes regarding relocation of a child forth of Scotland. There's a number of ways that disputes can be resolved. There's negotiation. So with traditional negotiation, it takes place between the parties and their respective solicitors. It can involve joint meetings between the parties and their agents, as well as the exchange of correspondence between agents. It's all undertaken with a view to trying to resolve the dispute as efficiently as possible. There's mediation. If communication between the parties has deteriorated, mediation provides a forum in which the potential relocation can be explored in the presence of a neutral third-party mediator. The parties can often explore various and creative solutions to resolve their dispute. The process is completely confidential, and the content of mediation can generally not be referred to in any subsequent litigation. There's collaboration. The collaborative process can be used to resolve disputes over relocation. This is a concept that was imported from the United States of America, and it involves the parties agreeing to try and resolve their dispute through a series of structured four-way meetings with their respective trained collaborative lawyers. Everyone involved signs up to an agreement at the outset in which they undertake to be open, honest, and make full disclosure. They also agree at the outset not to litigate with those solicitors involved. So if the collaborative process is unsuccessful and breaks down, the parties themselves would require to instruct different solicitors. With these three, negotiation, mediation, and collaboration, parties are able to maintain an element of control over their child's future without leaving it to a judge or an arbitrator who doesn't know them or doesn't know their child. But often, the parties' positions can't be reconciled through direct discussion and negotiation, and sometimes, therefore, an independent third party requires to make a decision. There is the option of arbitration, which is often overlooked. This may be a particularly attractive option in the current climate, where court business is severely restricted as a consequence of COVID-19. Parties can bilaterally agree to appoint a family law arbitrator who's essentially a private judge to resolve their dispute. The parties arrange a mutually convenient time and place for the arbitration to take place. The benefits of arbitration are that the process is confidential and it's generally quicker than court. The decision made in arbitration is actually binding on the parties. Finally, litigation in the sheriff court or court of session is available, and it's an increasingly common form of resolving relocation cases, given the binary nature of the decision at hand. So let's examine the position in law in Scotland. Scots law has express provisions in relation to international relocation of children. Section 2.3 of the Children's Scotland Act 1995 specifically provides that without prejudice to any court order, no person shall be entitled to remove a child habitually resident in Scotland from or retain any such child out with the United Kingdom without consent. Section 2.6 of the 95 Act provides that the person whose consent is required, whether or not a parent, is for the time being has or is exercising the right to have the child living with them, or otherwise regulate the child's residence, or has the right to maintain personal relations and direct contact with that child. So one parent cannot, therefore, take a child out of the United Kingdom without the express consent of the other. If one parent wishes to relocate to another country with the child and consent is not forthcoming from the other parent, the relocating parent must make an application for a specific issue order seeking authority to remove the child from the jurisdiction. That's in terms of Section 11.2e of the Children's Scotland Act 1995. If a child who's habitually resident in Scotland is removed from or retained out of the United Kingdom without the consent of the other parent, this would be wrongful in terms of the HCCH Convention on the Civil Aspects of International Child Abduction 1980, which is commonly referred to as the Hague Convention. Proceedings for the child's return would be instigated in the country to which they were wrongly removed. Section 6 of the Child Abduction Act 1984 criminalises the act of abducting a child from the United Kingdom. The lawyers in the room will also remember from their time at law school the old Scots law, common law offence of plagium, which is theft of a child. You'll note that the 95 Act makes reference to removal of a child from the United Kingdom. Strictly speaking, therefore, the legislation does not prohibit internal relocation in Scotland or in any other part of the United Kingdom. However, if a parent is concerned that the other parent is going to remove a child from their habitual residence to another part of Scotland or the United Kingdom, that parent should seek an interim interdict, an order prohibiting the child being removed from the jurisdiction, and they should seek surrender of the child's passport. An examination of case law makes it clear that the relocating parent should still obtain the consent of the other before moving within the United Kingdom, or they should seek a specific issue order if consent's not forthcoming. That was referred to in the case of GL against JL 2017. So let's look at the statutory framework and the Section 11 principles. When a court's required to make decisions regarding relocation of a child, there are some key legislative principles that must be considered. They're enshrined in Section 11(7) of the 95 Act. Firstly, the court shall regard the welfare of the child concerned as its paramount consideration. That's commonly referred to as the welfare principle. Secondly, the court shall not make any orders unless it considers that it would be better for the child that the order be made than none at all. We commonly refer to that as the no order principle. The court shall the court shall take account of the child's views, and in doing so, they need to take account of the child's age and maturity, and so far as practicable, give the child the opportunity to indicate whether they wish to express a view. If the child indicates they wish to express a view, the court should give them an opportunity to do so, and they should have regard to those views when making a decision. When carrying out these duties, the court also has to have regard to the need to protect the child from any abuse, which can include domestic abuse. So let's now look at the views of the child. The child's views can be considered in the process in a number of ways. The Form F9 procedure. It's a recently reformed document which is sent to the child by the court, which they can complete with their views. This can be sent to the child's school, for example, to minimise the potential for influence. The forms are confidential and are seen by the sheriff only, who can choose the extent of the information to share with the parties. A child welfare reporter can be appointed. It's a common means of obtaining the views of a child. It's where a solicitor or advocate is appointed by the court to explore their views, and a report is prepared for the court. A child psychologist can be appointed to take the child's views and provide an informed insight into the child's maturity and ability to express a view. The court can also consider appointing a curator ad litem. The curator's function is to represent and protect the child's interests. Their duty is to ensure that the child's views are communicated and protected. The curator can become a party to the case, and they can represent the interests of the child within the action where deemed appropriate. There's also participation of children in the process. In some cases, if the child's of sufficient age and maturity, the child can enter the process as a party, and they can instruct a solicitor or counsel. In other cases, the sheriff can speak directly to the child in chambers. So how important are the child's views? There's a presumption in law that a child aged 12 years or more is of a sufficient age and maturity to form a view. That's section 1110 of the 95 Act. Failing to give a child the opportunity to express a view can have serious consequences. In the case of S against S 2002, the child's mother was looking to relocate to Australia with her 7.5-year-old son after being offered a promotion. The sheriff dispensed with intimation of the action on the child and failed to obtain the views of the child. The case didn't reach a conclusion in the sheriff court until the child was 9. The sheriff then granted the specific issue order for relocation without obtaining the views of the child. The father appealed on the basis that the sheriff had failed to give the child the opportunity to express a view. The Inner House of the Court of Session upheld the father's appeal and held that when considering the duties in terms of section 11.7b regarding the views of the child, the court must discharge that duty at the time the order is made. In the case of S against B, a reporter later considered the views of the child and actually established that the child didn't in fact want to move to Australia. The views of the child are not determinative, unlike the welfare of the child. I've heard some family law solicitors say that children have a voice and not a choice, which should be viewed as part of overall considerations of their welfare. Whilst that may be true for younger children, in practice, if an older child has a strong reluctance to relocate or a strong reluctance to relocate, that may well be determinative. Such was the case in H against H 2010. The boy in this case wanted to return with his father to Australia to be closer to his wider family and participate in sporting activities, despite the fact that his mother and 13-year-old sister would be remaining in Scotland. His views in that case were undoubtedly instrumental to the court's decision to grant the specific issue order, which was actually sustained on appeal. So what does the process of litigation look like? The action is raised generally in the Sheriff Court or Court of Session. The most common form is the Court of Session. The Sheriff Court. In the Sheriff Court, the initial writ sent to the court for warranting. It will then be returned to the pursuer with a warrant and served on the defender, the non-consenting parent. It could be served on the defender or their agent by post, or in terms of the most recent coronavirus-related changes, by email, where either the defender consents to that or it's granted by the court. Alternatively, service could be effected through sheriff officers. There's usually 21 days for the defender to lodge a notice of intention to defend, following upon which the court will fix a timetable which requires the defender to lodge defences, and it provides a time for the parties to adjust their respective pleadings. There's then an options hearing, and at some stage there will be a proof fixed. The proof's an evidential hearing. A pre-proof hearing will be assigned, usually to allow the parties the opportunity to address the court on the state of preparation for proof. A proof hearing will then take place, usually over about 2 or 3 days, during which evidence is led. The parties may have lodged affidavits, sworn statements, for the evidence in chief of some of their witnesses. Witnesses may give evidence in chief in court, and witnesses might be cross-examined. Documentary productions are usually lodged and referred to by the parties in support of their respective positions. Following submissions, including possibly written submissions, a decision is made by the court, usually in writing. Whilst the court is supposed to deal with these applications expeditiously, the process can typically take between 6 and 12 months. So, how have the courts approached this issue? The Scottish and English courts have taken a rather different course with regards to how the issue of relocation is approached, and the contrast between the two is important to examine. Let's look firstly at the English approach. In the early case of Poland Pole, the English Appeal Court, applying the presumption that in place at that time, when a marriage ended that a child would remain in the custody of one parent. The court emphasised that it should not lightly interfere with the way of life selected by the custodial parent, as it would introduce strains on that parent, interfere with any new marriage, and might well in due course reflect on the welfare of the child. It appeared, therefore, that there was a presumption in favour of relocation. The issue was revisited in the Court of Appeal in Payne and Payne in 2001, and the approach was somewhat different. The court in this case superficially rejected any presumption in favour of the reasonable proposals of a primary carer to relocate, but it endorsed the weight to be attached to the emotional and psychological well-being of a primary carer as part of the evaluation of the welfare of the child. The court stated, inter alia, that it must consider whether the mother's motives are genuine or an attempt to frustrate the father's relationship with the child, and consider the father's basis for refusal. Importantly, the court went on to emphasise that in most relocation cases, the most important assessment for the judge is the effect of the refusal of the application on the mother's future psychological and emotional stability, an assumption by the court that the primary carer tended to be mothers. Following this case, it continues actually to be the leading authority in spite of some criticism. And it endorses the view that where a primary carer seeks to relocate for genuine reasons, they will usually be allowed to do so. In K and K 2012, the court in that case had to depart from that general principle established in Payne, and they had to apply straightforward welfare criteria, as the court was actually faced with a shared care situation. But in that case, the court still emphasised that the ratio of Payne was still good law for other cases. So let's examine the approach in Scotland. The approach of the Scottish courts to the issue of relocation has been markedly different to that of the English courts. Relocation is viewed entirely through the prism of the welfare of the child. Indeed, it's the golden thread that runs through the reported case law. One of the leading Scottish authorities on relocation is the case of M against M 2012. In this case, the court considered the various English authorities, including the leading case of Payne and Payne. The court in M&M rejected the principles of Payne and any notion or presumption in favour of relocation. Indeed, it reiterated that the wishes and interests of the parent will not be given undue weight in particular. Instead, the effect on either party of any order sought is taken into account insofar only as it affects the welfare of the child, which is a paramount consideration at all times. In M against M and in S against S 2012, the respective courts emphasised that although a strict legal burden of proof doesn't exist, the evidential onus is on the party seeking an order to show, on the balance of probabilities, that the welfare of the child requires the order to be made. In S and S, the court took the opportunity to remind that each case requires to be considered on its own facts and circumstances, and the court has to have regard to all factors affecting a child's welfare. The Scottish position is actually very well summarised by Lady Smith in Donaldson against Donaldson 2014. And I quote, "Since the decision of this court in the case of M against M, it's been clear that on an issue of relocation, it is no part of our law that a judge requires to regard any particular factor as having greater weight than any other. It would, for instance, be wrong to proceed on the basis that there is a rule that the most crucial assessment required is to the effect that a refusal of the relocation application will have on the applicant. This is often conveniently described as a presumption-free approach. It accords with the court's duty to regard the welfare of the child as a paramount consideration. That's not to say that in an individual case there may not be features which are of particular importance when considering the welfare of the child concerned. The availability in each jurisdiction of some particular medical treatment or educational provision that the child requires would be an example. Much is going to depend on the factors of each case. It would be wrong to say that we've got a checklist in Scotland in view of the paramountcy of the child's best interests. However, in M against M 2008, Sheriff Morrison, in this case, which has been referred to in a number of subsequent cases, listed a number of factors which the court ought to consider when making decisions about the best interests of a child in a relocation dispute. It's a useful list for parents that are proposing to relocate to consider. The list of factors includes the reasonableness of the proposed move abroad, the motive of the parent wishing to take the child abroad, the importance of contact with the other or absent parent in the child's life, the importance of the child's relationship with their siblings, grandparents, or other members of the extended family who are left behind, the extent to which contact, if appropriate, can be maintained, the extent to which the child may gain from a relationship with family members as a result of the proposed move, the child's views where he or she is of an age to express them, the effect of the move on the child, and it's always the focus on the child, the effect of refusal of the specific issue order on the applicant, particularly where that parent already has a residence order. But in these cases, it's always linking it back to the subsequent effect on the child. So then the overall consideration, the effect of refusal on the welfare of the child, and again, the overarching consideration whether it's better for the child to make the order than no order being made at all. So I thought it'd be useful to try and give some examples of cases where relocation has been granted and refused. So there's some cases where the parents have been given the green light to go. In F against F 2015, a specific issue order was made which permitted a mother and 2 children to relocate to Australia, where the court held it was not in the children's best interests to remain in Scotland. In M against SS, the mother of a 6-year-old child was offered a promoted post on the condition that she relocates to Houston. The Inner House of the Court of Session was unable to criticise the sheriff's assessment that the preservation of the child's relationship with the father was overall of a lesser importance than maintenance and development of his primary relationship with his mother, who in that case was described as the bedrock of his life. In DY against LY in 2011, a specific issue order was granted which allowed an American father to remove his 11-year-old child from Scotland to the US, where the proposed relocation was reasonable and it outweighed the reduction in direct contact with the child's mother. The father in that case was extremely homesick, and the child, who was born in the US, had a strong desire to relocate. There's some cases where specific issue orders have been refused, and if you look at the Scott Court's website, if you do a quick search on Google, that tends to be the cases that dominate, although that doesn't mean, for example, that there's more cases that have refused. It's more just the recent cases seem to be, when you do a Google search, refusals. In Foreman against Foreman 1998, a specific issue order for a mother to relocate with her children to Australia was refused, as in that case, the mother's motive was her desire to go there, which was her place of birth, rather than any motive being in the child's best interests to move there. In C against M 2012, a specific issue order to relocate to New Zealand was refused, where there was good, beneficial and regular contact between the children and their non-resident father, which couldn't be replaced through telephone and internet contact from a country with an 11-hour time difference. In that case, the mum's failure to consult with the father on important matters actually compromised her position and her claim that she would do everything she could to facilitate and promote the relationship between the children and their father. The last case I wanted to give an example of is X against Y 2007. In that case, a specific issue order to relocate to the United States, which was the home country of mum's new partner, was refused. In that case, primarily because the mum's new partner was a convicted sex offender, and that reduced his employment and health prospects. And in that case, there was a child who suffered from leukemia, so it was a significant factor. The reluctance of the children in that case also carried significant weight. So let's think about evidential considerations in a case for parents that want to relocate. The first thing that's of crucial importance, having considered the commentary in case law, is for the parent seeking to relocate to consult with their ex-partner, and once agreed, consult with the child to allow them an opportunity to express their view, and if they give a view, to consider it. The child's views do matter, and it may well strongly influence whether a move should or should not take place. Plainly, a parent that is seeking to relocate requires to satisfy the court that they have well thought through plans and they've carefully considered the practical arrangements involved with relocating. The plans will be closely scrutinised by the court. In M against M, the court was critical of a mother's preparations for the move. It seemed to be more of a pursuit of a dream to relocate to a place in the sun in Spain with her new husband. A parent seeking to relocate should be able to provide evidence to the court of accommodation, employment or financial support, education for the child, care arrangements, medical facilities, proposals for contact with the parent left behind. The court, at the end of the case, should be left in no doubt about the child's life, the opportunities, activities, and lifestyle that would be offered to the child in the proposed country of relocation. In DH against GH, the sheriff was particularly unimpressed with the pursuer's relocation request, as she'd not seen the apartment she was planning to move to. She hadn't decided when the move was going to take place, and she couldn't guarantee that her child would be enrolled in the school she was looking at. So the court was very critical of a lack of preparation. Doing your homework as a parent proposing to relocate is critical in applications in specific issue orders for relocation. Many applications have been refused on the basis that the court's not satisfied about a particular aspect of a child's welfare that is associated with a proposed move. It's particularly important to consider a child who, for example, has a high level of medical needs or requires support in terms of their learning. It has to be demonstrated to the court that there will be ample provision and support for that particular child in the proposed country of relocation. In MK against TD 2019, the court refused to grant a specific issue order where there was a lack of evidence about medical provision in Germany for a child with selective mutism. So now, my colleague Zoe and I are now going to try and answer some of your questions. So if you give me an opportunity just to review some of those. And while we're talking, if you do have a question that you want to ask on anything that has been covered or something you think has not been covered that you want an answer to, please go to the bottom of the screen. So you'll see at the bottom where it says participants, chat, share screen, there's a button that says Q&A. If you click on that and you type your answer, Zoe and I will be able to see that. So the first question that we seem to have is about the impact of the coronavirus situation on applications for relocation. So I have a case ongoing at the moment in quite a small jurisdiction, an island court, in fact, where there's an ongoing action in relation to relocation. That's been ongoing since October last year. And in that case, the sheriff recognised that expeditious decisions required to be made regarding the relocation. However, the problem that we faced is that in that case, the coronavirus pandemic really came to a head in the beginning of March, and we were supposed to be going to proof in April. So the difficult thing in that case is that it's actually holding up getting a conclusion in that case, which is causing the Parent I Act for the proposed relocating parent, who is very stressed about the delay. There's already plans in place that were supposed to be put into place by the summer this year. And the children themselves are confused because they thought there was going to be a move by April this year. The other consideration in terms of the coronavirus pandemic, I think, is that in that situation where the court is being asked to assess the best interests of a child, the court has to consider the current situation. So is there anything prohibiting travel from the United Kingdom, which will include the advice from the government? But the court's also going to look at the conditions of the proposed country of relocation. So they're going to look at the R rate in the other country. They're going to consider the general conditions and the general measures and healthcare that's in place in that country. So I see there's some more questions. There is one question saying about sending the slides. I'll speak to our marketing team, but I have no difficulty in sharing the slides with you at the end. I've got one question which is about resources that I would recommend to read further on the issue of relocation. That's actually a really good question. If you have access to Westlaw, there's a really good topic that has been raised about relocation, and there's a guide that basically goes through the law. So it takes you through the statutory framework, it takes you through the important cases and some of the factors that the courts have considered. That guidance also covers the important considerations in terms of Hague Convention applications. So there is one question. One of the questions is, what sort of recourse would a left behind parent have if the primary carer did indeed up and leave without obtaining court sanctions, and particularly to a jurisdiction which may not have close ties with Scotland? Again, a very good question, and my colleague Zoe Ray has good experience of Hague Convention cases and wrongful removal of children from Scotland, and she might be able to talk us through a little bit about Hague Convention cases and actually cases where we don't have any agreements with countries for return of children. So Zoe, can I pass over to you?
Yes, thanks, Gary. That is an excellent question. Gary's touched briefly on the Hague Convention, which it's what covers wrongful removal of children from their habitual residence and retention of children in countries away from their habitual residence. So in the question, it's been asked what recourse would a parent have if the primary carer took the child out of Scotland without sanction from the court. So if it was a country that was a signatory to the Hague Convention, then the first port of call really would be to contact the government in your own country, who would make contact with the government in the country where the child had been taken. And then the government in the country where the child had been taken to would make the necessary provisions with a solicitor there to start proceedings to have the child returned. The Hague Convention cases that we deal with, and my colleagues in Glasgow and I deal with them fairly regularly, they're some of the most interesting, complicated and difficult cases that we deal with, and they're almost always involving people who are in really quite difficult situations. When you're dealing with a Hague Convention case, perhaps surprisingly, bearing in mind everything that Gary said, the focus of the court is not looking at welfare, best interests of the child, or any of the plans in either country for what the child's life might look like. Really, if it is established that the child has been wrongfully removed or retained in the country that it's been brought to, then unless one of four very specific defences can be established, then the child will almost always be returned. The defences are very, very narrow, and it tends to be that parents often will try and invoke a defence, and they're just frankly not able to do so. The two that are most commonly used, as we see, are the defence of consent, where the parent will say, well, actually, I did have the other parent's consent to bring my child here, or to keep my child here after I brought them here. Or they will allege that there is a grave risk of harm to the child in being sent back to the country from which they came. That's one that we see quite a lot, and it is quite a high hurdle to get over. The important thing to bear in mind about those sort of cases is the grave risk of harm is purely a risk of harm to the child. It doesn't look at in any detail any distress or inconvenience or upset to the parent of the child. It's very much focused on risk of harm, and it has to be a serious risk of harm to the child. And in the vast majority of cases, the children are returned, and they return very quickly. Problems do arise when your child has been taken to a country that is out with the Hague Convention. That, for obvious reasons, can make it much more difficult. And you will find often that countries that aren't signatories to the Hague Convention are countries where mechanisms for dealing with return of children are fairly primitive or non-existent. If you're acting for a client whose child has been taken to a country, for example, in the UAE or countries in that region of the world, it can be very, very difficult. And some of you will be aware of stories that have been in the media over recent years of children that are just taken to these countries, and it is very difficult, if not impossible, to get them back. But the main thing is to get advice, and to get advice as soon as possible.
Just touching on that, Zoe, the other thing that we covered in the presentation is there is the option to report to the police to investigate whether a criminal offence has been committed. In terms of my experience, I think the most effective way of trying to deal with the situation, if it's a Hague Convention country, is actually to use the Hague Convention process rather than the criminal process, which, if a parent is in another country, you have to rely on extradition proceedings, for example, and it's a very long and difficult process to try and convince the Procurator Fiscal and others that the extradition proceedings should be started for a case of that nature. We're looking at one more question that I've got coming through just now about the risk of harm to the child, focused around the risk from domestic violence or from dangerous countries such as war zones. And I think the answer to that, Zoe, you'll be able to give a little bit more information about that. But from my experience, the countries, the courts tend to consider both aspects. So in terms of domestic abuse, the courts can consider the impact that returning to a country, if the child is likely to face domestic, the parent is likely to face domestic abuse and the child's likely to be affected by that, is a factor that the courts can consider. And there have been cases where the court has refused to return a child where there's concerns over the country to which the relocating parent has taken the child. Zoe, do you have any more thoughts on that?
Yes, I suppose in relation to the Hague Convention cases, when my colleague talks about Hague Convention, she sometimes describes the grave risk of harm defence as the war zone defence, because the standard really is pretty high. There will be a number of cases, and I've seen a number of Hague cases, where the parent who has removed the child alleges that there has been domestic violence in the relationship, both prior to and since the child has been born. While evidence of that nature will have to be put before the court, it's not a forensic exercise that's undertaken. And in the Hague Convention, what partially underpins that is that there is a mutual respect between the countries, that the legal systems in all of the signatory countries are able to deal with these issues. So the Hague Convention isn't designed to send children back to a jurisdiction where there is no mechanism to deal with these types of issues. If the tests in the Hague Convention are met, then the child will be returned, and the court in the original jurisdiction will deal with these issues. That parents can make applications both on the criminal and on the civil side that they need to make. That said, if there is a situation where clearly there is a significant risk of harm to a child to be returned to a particular place, then that obviously can be taken into account.
So I'd just like to thank everyone for joining the webinar today. I hope that you've enjoyed it and that you have learned something from joining our discussion today. Again, if you have any other questions, my contact details are now being shared on the presentation. So feel free to get in touch with me. You can either give me a phone on the mobile number or drop me an email, and I'm happy to answer any questions about relocation. I'll speak to our marketing team about the slides and about the information that I spoke about that was available on Westlaw, about trying to share that with delegates. So thank you all, and I hope you all have a good day.